request.
My Lords, my Lady, I appear with Miss Rachel Barnes, King's Counsel, and Mr James Sheehan, King's Counsel for the Appellant Bank, UniCredit. Mr Fred Hobson, King's Counsel, on the right appears for the Respondent, Celestial, and Mr Akhil Shah, King's Counsel, and Miss Leonora Sagan appear for the Respondent, Constitution.
Yes.
The Appellant is a bank, and the Respondents are aircraft leasing companies. The issues, as you will have seen on these two appeals, concern the application of UK or US sanctions legislation to payments made under standby letters of credit that UniCredit advised and confirmed to the Respondents. And the appeal falls into four parts. First, the scope of sanctions under Regulation 28 of the 2019 Russia sanctions regulations. Second, the effect of Section 44 of the Sanctions and Money Laundering Act, which in some cases provides a defence to a person who acts in the reasonable belief that he's affected by a sanction. The third part is whether US sanctions legislation is relevant to this case. And the fourth part is if US sanctions is relevant, what is the relevant content of US sanctions? And how do they affect payment under the letters of credit? I propose to deal with the first three of those issues, and then Ms Barnes will deal with the fourth issue on US sanctions, which is approximately the same split as you will have seen between the Celestial and the Constitution skeleton argument. So the facts, or the core facts, giving rise to the appeal are relatively straightforward and not controversial. In total, UniCredit advised and confirmed 12 letters of credit that are subject to these appeals. But I can take one of those as effectively an exemplar of the points that I'm going to make. And if your Lordships have the consolidated core bundle, there is, for reference at tab 12, a chronology of the agreed events. And I'll just take you through the key ones in relation to one of the letters of credit. So first of all, on the 21st of December 2005, Celestial entered into an aircraft lease agreement with a Russian airline called Airbridge Cargo Airlines, covering the lease of a Boeing 747-400 aircraft. And the particular lease we'll be looking at is reference 35420, and that's how it's referred to in the pleading. So the lease was entered into on the 21st of December 2005. On the 21st of August 2017, so sometime later, Bank, a Russian bank, issued a standby letter of credit in favour of Celestial as the lessor, as security for Airbridge's obligations under the lease. And shortly afterwards, on the 23rd of August 2017, UniCredit advised that letter of credit to Celestial and added its confirmation, thereby assuming its own payment obligation under the credit. And if I can ask your Lordships to look at the terms of the LC and the confirmation, which you will find in the core bundle at tab 19. This is the advice and confirmation sent from UniCredit to a company now known as Celestial. It's dated, as I said, the 23rd of August 2017. It says, Dear Sirs, issuing bank irrevocable transferable standby letter of credit. Then it says, the above issuing bank, which is Bank, has opened an irrevocable transferable standby letter of credit in your favour, copy of which is enclosed. Next paragraph, we herewith confirm this irrevocable transferable standby letter of credit and undertake to honour drawings under the above mentioned letter of credit up to and not exceeding the amount of $3.6 million, provided that the documents are presented in strict conformity with the terms and conditions of the standby letter of credit. And then the letter of credit itself follows on the next page. And if I can just show you the relevant parts. Under the heading 79 narrative, you see that Spare Bank is issuing standby letter of credit and requesting UniCredit to add its confirmation. And then if you go about 2 paragraphs down, you should see a paragraph that begins, this standby letter of credit. This standby letter of credit is provided in connection with, and for obvious reasons I stress those words, in connection with the lease of one Boeing 747-400 aircraft with serial number 35420 to Airbridge Cargo Airlines, LLC, under aircraft-specific lease agreement dated 21st December 2005. And then if one goes to the penultimate paragraph on this page, it says, this standby letter of credit, however, creates primary obligations on us and is independent from the lease. And then it contains an undertaking by Spare Bank to authorise the beneficiary as lease manager of the aircraft to draw on UniCredit, going over the page. Draw on UniCredit an amount or amounts not exceeding a total of US dollars $3.6 million by signed written demand certificate in the following format, with the bracketed sections and the blanks completed. And then under the heading quote, is on page 286 of the bundle, the LC sets out in the usual way the form in which a demand must be made in order for the beneficiary to obtain payment. And it must be in this form, it must say, on behalf of the named beneficiary, the undersigned hereby draws upon irrevocable transferable standby letter of credit, etc., issued by Spare Bank, due to Airbridge Cargo Airlines having failed to comply with its obligations under an aircraft-specific lease agreement dated December 21st, 2005, made in respect of the aircraft with serial number 35420, and instruct you to transfer US dollars, and then the amount, to, and then the bank details immediately. So that's the form of the demand required under the LC. And then in the next paragraph, after the words unquote, it says drawings under this standby letter of credit will be honoured upon receipt of such a demand certificate by mail, courier service, or by hand at the counters of the confirming bank, and the confirming bank will make payment to the beneficiary's account specified in the demand certificate, value date no later than close of business on the 4th business day. And then if we go to page 288, we see just at the top of the page Spare Bank's instruction to UniCredit to advise the standby letter of credit to the beneficiary and to add its own confirmation. Of course, would make UniCredit separately liable.
And the strictly complying documents referred to on page 287 is simply the demand in,
That's right.
In the form, no other documents.
Exactly. So it's a standby credit, and therefore a compliant demand is all that was required. So that's the LC. On the just to go back to the chronology, on the 24th of February 2022, Russia invaded Ukraine. And on the 1st of March 2022, the Russia sanctions regulations, which had originally been issued in 2019 on the invasion of Crimea, were amended. In particular, they were amended to introduce the sanction in Regulation 28 that is the subject of the present dispute. And my Lords, my Lady, I will return to the particular terms of Regulation 28 in a moment. So the relevant sanction comes into force on the 1st of March. On the 2nd of March, Celestial makes demand under the LCs. And just to take the example demand, that's at tab 20 of the core bundle. and as one would expect, it is in the form, exactly in the form required by the LC. You see what it says there. It refers to the fact that Airbridge Cargo Airlines has failed to comply with its obligations on the Airfract Specific Lease Agreement, and it gives an instruction in the form required to UniCredit to transfer $3.6 million to, and your Lordship see the bank details set out there, which is a bank account in JP Morgan Chase Bank in London. So that's the demand. Now, as a contractual matter under the letter of credit, and I showed you the provision, payment would then have fallen due, I think, on the 10th of March, which the relevant number of business days provided, and that's common ground. But UniCredit declined to pay the demands on that date. And I'll come back to the reasons in a moment. On the 15th of March, Celestial issued the present proceedings in relation to this and other credits. And we can find those, the form of the proceedings at tab 17 of the core bundle. And if I can just ask you to turn to page 266 of the bundle, you'll see what relief was sought, which is at paragraph 18, a declaration that Regulation 28, which was the regulation that UniCredit had relied on in order to justify non-payment, seeks a declaration that Regulation 28 does not have the effect of suspending or affecting performance of payment. And at paragraph 19, there was a claim for $45 million, which was the total amount under all of the outstanding letters of credit. Alternatively, a claim for damages, and the claim is for payment in a specified foreign currency, US dollars, being the currency which corresponds to the payment obligations. And then the sterling equivalent is set out, and there is also a claim at paragraph 20 for interest, and in the prayer there's a claim for costs. So that was the claim made by Celestial, and a similar claim was made by Constitution. Now, the next thing that's happened on the chronology is, as I will show you in a moment, the Russia sanctions regulations incorporate a licensing scheme whereby a license can be given to permit what would otherwise be a sanctioned activity. And on the 24th of March 2022, UniCredit applied for such a license, and it applied to two organisations, one called the ECJU, the Export Control Joint Unit, which deals with trade sanctions, and one to the OFSI, the Office for Financial Sanctions Implementation, which deals with, essentially, with financial sanctions.
I assume, by the way, that I noticed the pleading makes reference to some intermediate correspondence.
Yes.
Where the reason for non-payment was given.
Yes.
I mean, was that just we're not obliged to pay, or we're not obliged to pay unless or until we get a license?
I will have to have a look at the exact terms of the correspondence, but I think the position taken is that we're not obliged to pay under Regulation 28. Let me find out whether the license was raised at that point. That's what you're asking.
Broadly speaking, yeah.
Yeah.
There's a reference to paragraph 14 at page 264 to some intermediate correspondence. Don't know whether we need to look at those, whether we get any.
Might I come back to you on that? As I said, the application for a license was made shortly after the proceedings were issued, and the license was eventually granted, first from ECJU on the 22nd of September 2022, and that license you will find in the supplementary bundle at page 144 at tab 15. This concerns Regulation 28. And you see that from the schedule to the licence on page 146, which permits the provision of financial services for funds of the nature identified in the licensee's licence application on 24th March 2022, which would otherwise be prohibited under Regulation 28 of the Russia sanctions regulations. That licence was, however, conditional, as you see in paragraph 2, to a licence also being issued by the Office of Financial Sanctions Implementation, OFSI, in relation to the receipt of funds from spare bank and payment. And that licence you will see at tab tab 20, and that was granted on the 13th of October 2022. So having obtained those licenses on the 14th of October 2022, UniCredit paid some of the outstanding letters of credit, and the remainder of the letters of credit were paid on the 25th of November 2022. And the reason for that difference in time, broadly speaking, is to do with the US sanctions part of the appeal, and I'll ask Ms. Barnes to deal with that in due course. But the upshot was that within a month or so of the grant of the licence by the UK authorities, the monies have been paid. However, as your Lordship will have seen, despite payment having been made, Celestial and Constitution continued with the proceedings that they'd issued, and they continued with the proceedings in order to seek interest and costs on the ground that UniCredit should have paid back in March when the demand was made, and that justified the issue of proceedings and also the award of interest between March and the date of payment.
The application that preceded these licenses is where it referred to both receiving payment from Sberbank and making payment to the beneficiaries.
Yes, it is. Tab 7. And that sets out the basis for the license requests.
So it linked payment with receipt.
Yes, what was being requested at page 84 is a license to receive funds and to pay to aircraft. So that means that all that means that the question of whether UniCredit should have paid in March when the demand was made, or was entitled to wait until it's been licensed appropriately, remains relevant in relation to interest and costs. And I've looked at that in relation to one letter of credit, but the position is essentially similar, although the timings may be slightly different. So those my lords, my lady, is a sort of relevant sequence of events, and on that basis, I then turn to the relevant legislation, which I have in the authority bundle, starting with the primary legislation at page 5 of the authorities bundle, which is the sanctions and anti-money laundering Act 2018. Starting with the preamble, it is, as it says, an act to make provision enabling sanctions to be imposed where appropriate for the purposes of compliance with United Nations obligations or for other international obligations or for the purposes of furthering prevention of terrorism or national security, etc. There are various, and the relevant regulations are made under this legislation. There are a number of relevant provisions that relate to the making of secondary legislation under this Act. If I can just identify them. First of all, if you turn to page 6 of the bundle, paragraph 1 is a power to make sanctions regulations. Paragraph 1.1 provides that the Minister may make them. It is necessary, Your Lordship will see in paragraph 1.3, for the regulations to state the purpose of the regulation. Also, if we go to, there are various reports. There are various reports that the relevant ministers have to give in relation to regulations, some of which we'll look at in a moment. And I think the other parts of this Act that are relevant are paragraph section 43 on page 31, which provides that where regulations are made under section 1, the minister who made the regulations must issue guidance about prohibitions and requirements imposed by the regulations. And I think the other provision we need to look at in this Act at the moment is section 44, just so we have it in mind when we come to look at it later, which is that there is a protection for acts done for the purposes of compliance. And broadly speaking, that protects a person who is acting in the reasonable belief that his act is in compliance with sanctions regulations. And I'll come back to that when I get to that part of the appeal later. So that's the primary legislation. The relevant secondary legislation is the 2019 regulations, which begin at page 68 of the authorities bundle, tab 4. They are the Russian Sanctions EU Exit Regulations 2019, and the regulation, well, perhaps I should just first show you the statutory purpose of the regulation, which is at page 72, section 4. The regulations contained in this instrument that are made under section 1 of the Act are for the purposes of encouraging Russia to cease actions destabilising Ukraine or undermining or threatening the territorial integrity, sovereignty or independence of Ukraine, and promoting the payment of compensation by Russia.
That second law was introduced later, I see, in 2023.
Yes, you're absolutely right. So that's not a relevant consideration for the purpose of well, it was introduced on the 20th of June 2023. That's right. It was introduced later. And the regulation that we are principally concerned with is at regulation 28, page 86. And this was amended in the way one sees on the 1st of March 2022. It previously referred to military goods and military technology. And so it was essentially broadened on the 1st of March 2022 to extend to what is called restricted goods and restricted technology. And the definition of restricted goods, its common ground, includes aircraft. And 28 provides, and we are principally concerned with Regulation 28.3, that being the one that we principally rely on, which provides that a person must not directly or indirectly provide financial services or funds in pursuance of or in connection with an arrangement whose object or effect is, and then I would highlight 3C, directly or indirectly making restricted goods available sub to for use in Russia.
You say that's the one we're primarily concerned with. I'd understood that that's the only regulation that you rely on. I mean, I can see that the 1 and 2 may shed light on the meaning of 3, but you don't say that you independently come within those.
Right. I mean, it may be that there are other ways in which one could thread what happened within this regulation, but the one we rely on is 28.3C. Well, 28.3C and 2 is sufficient for use in Russia. Just so we have all the definitions, restricted goods, that, as I say, is common ground, includes aircraft, funds are defined in section 60 of the primary legislation, SAMLA. And again, it's common ground that that would include the fund transfers that we're concerned with. And then arrangement is, perhaps we should just look that one up, is at page 69 of the bundle, section 2 of the regulation 2. And that's defined as including any agreement, understanding, scheme, transaction, or series of transactions, whether or not legally enforceable. So if we go back to Regulation 28 on page 86, I make this point on sub 3, 28 sub 3, which is important. But the way in which this is drafted is that in linking the provision of funds to the arrangement, the clause uses the language in pursuance of or in connection with an arrangement. In other words, it uses the language of connection, and it is not limited, as it could have been had it been drafted in that way, to a situation where the provision of funds causes or facilitates the making or performance of the arrangement. And in my submission, that's an important distinction. The drafter has used the language of connection, not the language of causation or facilitation. And just to complete the relevant provisions of the regulation, all of that is subject to the licensing regime.
So in 28.3, when it talks about in connection with an arrangement whose object or effect is, that's in the present tense.
Yes.
Do we read that as is or was?
We read that as yes, in the sense that we read that as a description of the arrangement. So you ask yourself the question, does this arrangement have the effect or object of supplying goods? And that could apply, that's a quality of the arrangement, whenever the arrangement was entered into and whenever the supply was going to be made. Well, that's a point that I need to come back to later on, but it should not be read, as I think the claimants seek to read it, as an arrangement which will have the object or effect of supplying aircraft for use in Russia. In just to complete the regulation, the licensing provision is at Regulation 65, page 93, which provides that the prohibitions do not apply to anything done under the authority of a licence issued by the Secretary of State under this regulation. So if we just go back again to Regulation 28, it was conceded in the hearing below that by the lessors and accepted by the judge that the lease was an arrangement whose effect was to make available aircraft for use in Russia, at least until it was terminated. We see that in, if we can just look at the judgment below, which is in tab 15 of the core bundle, at paragraph 108.
Sorry, can you give me the page reference again?
Sorry, page reference 221 of the bundle. If you perhaps just start at paragraph 106, and I should say these paragraphs are in the section of the judge's judgment in which he set out the claimant's contention. And he recorded those contentions starting at 106, that 28.3 breaks down into three elements, which we would agree with. That there's got to be a provision of funds, it's got to be in pursuance of or in connection with, and it's got to be in connection with an arrangement whose object or effect is the supply of restricted goods. Now, in the argument below, 1 and 3 were conceded by the claimants. We see that at paragraph 107 and 108. 108 says, so far as element 3 is concerned, the claimants accept that each of the leases was until termination of the leasing an arrangement whose object or effect was the supply of restricted goods to or for use in Russia or to a Russian person. There was therefore a relevant arrangement for the purpose of regulation 28.3 until termination of the leasing, which I think goes to your lordship's question.
Yes.
We would say that's obviously right, and I'll develop that point in a moment, although we wouldn't qualify it by reference to the termination of the lease.
No, well, that's why I asked the question.
Yes. We would say that as I say, that the statement in Regulation 28.3 is asking a question about the arrangement. What is the object of the arrangement? And the object of the lease is to supply aircraft to Russia, and therefore it is a qualifying arrangement. Well, it's not asking the question, is this arrangement, which, as I said, which will in the future involve the supply of aircraft? It is a question about the nature of the arrangement.
I mean, the question we'll come on to doubtless is if the lease was terminated and you have an independent payment obligation. Is that called? You say yes.
Yes, yes. And might I come back to that point? It's obviously an important one. But the way in which it was argued in the court below is that in effect one was not concerned with elements 1 or 3 because they were satisfied. Well,
only until termination of the leasing.
Right, and because termination of the leasing, I think, was not until after the demands were made in all cases, or at least in the case that
yes, the chronology is a bit unclear.
Yeah. Certainly in relation to the example lease I was showing you.
I mean, clearly the demand, if correctly made, was made following the default.
Yes.
But it's not clear in all cases that it was made
No.
following termination.
I mean, just looking at the chronology, one sees that the celestial, I think page 193 of the Bible, the demand was made on the 2nd of March. And the termination of the celestial leasing was on, or at least the demand under the AAL LLCs
Exactly.
was made on the 2nd of March. And on the 3rd of March, Celestial terminated the celestial leases. So the chronology is not entirely clear in that respect, and wasn't really clarified below because it's, as far as I understand the judgment and the way the arguments are recorded as having been advanced, the date of termination of the leases was not seen as a relevant factor.
Constitution seems to have terminated the leases first and then demanded.
Yes, it seems to be the other way around for them. But the way it arose below, at least as the arguments are recorded by the judge, is, and one sees this in paragraph 109 of the judgment, which again is recording the way the claimants put their case, is 109, the critical dispute focuses on element 2. The question is whether payment by UniCredit to Celestial under the letter of credit is in pursuance of or in connection with the supply of aircraft under the leases for the purposes of Regulation 28.
But timing generally is going to feature quite large in the analysis of the judge's judgment, so we might as well at least note this timing issue from the off.
But as I say, the way in which the judge, the way in which the judge was asked to analyse it was in relation to what was element 2, which is the connection. Now, I mean, in our submission, on that basis, our argument is a simple one. We say that this arrangement, a lease for aircraft provision to a Russian for use in Russia, this lease was an arrangement, was a qualifying arrangement, because the effect and object of the arrangement was to supply aircraft for use in Russia. That's self-evident because it was a aircraft lease to a Russian airline.
If you terminated the lease at a time when the aircraft was, say, at Heathrow, or Ireland, or somewhere outside Russia.
Well, if I say that wouldn't. If you ask yourself the question, what's the object of the arrangement? The object of the arrangement doesn't change because it's been terminated or because it's been performed. Well, it is still an arrangement, the purpose of which is the leasing of aircraft.
Yeah, I mean, you're relying on 28.3c, particular 2, which is making available aircraft for use in Russia.
Yes.
So, I think you would say that's a descriptor of the arrangement.
It is exactly. It's a descriptor of the arrangement. It's
which
not a
is,
descriptor.
and it applies whether or not the aircraft happens to travel to Heathrow.
Quite, because I mean, who knows where the aircraft's going to travel? Who knows what steps will be taken under the contract? Whether it will be terminated. If it is terminated, what that means for the continuing obligations of the parties. And one of the points, sorry to sort of trail this, but one of the points that I was going to come back to later on this particular point is that this is a provision which has to be understood, it's a criminal sanction, has to be understood with certainty by the party whom it affects, UniCredit in this case. So one needs, and that will not be achieved if UniCredit has to investigate what the current state of the performance of the arrangement is. And the point I do stress is what the regulation is aimed at is not what has or hasn't been carried out under the arrangement, but what the nature of the arrangement is.
But until these sanctions came into force, the aircraft were not restricted goods.
Well, they were not. Do you mean restricted goods in terms of as that term is defined in the? Yeah. So well, clearly they weren't because that term was only introduced in
so,
the 1st of March.
So they're not restricted goods until it comes into force. I think the question is whether after the lease is terminated, there is an arrangement for making them available for use in Russia after the leases are terminated. And then the question is, how does the payment obligation lock into that chronology?
If the leases are terminated, that might or might not have the effect that the aircraft are no longer available for use in Russia. That would depend on the terms of the contract. It might depend on the factual circumstances. I mean, for example, and I just use this as an example, you might have an arrangement that on termination, if the lessee pays for the aircraft, then it can keep that kind of lease.
Well, we haven't looked at the terms of the aircraft leases, but on the face of it, if the leases are terminated, it's not open to the lessee just to carry on using them.
Well,
unless you show me provisions.
no, and I'm not suggesting that's the position in this case. But what I'm suggesting is that when one is interpreting the regulation, one has to bear in mind that it's aimed at a very broad set of different arrangements. One doesn't know in advance what arrangements one's concerned with. I don't know, because we haven't looked at the lease terms, what the position would be in this case, but demands have been made for payment under the lease agreements. It may well be that the demands for payments represent the liability of the lessee for the value of the plane, it not having returned it. And it may be in some arrangements, again, I don't need to make the point in relation to these ones, that if at the end of the lease, demand is made, the aircraft is not returned, but demand is made for the value of it, and that demand is satisfied, that the lessors would not then have any right also to recover the aircraft, having been paid for it. And I put forward that example just to say that the practical consequences in terms of whether aircraft will or won't be available for use in Russia after termination will inevitably depend on the particular terms of the agreement. And my submission is that is not the way in which this regulation works. What it is doing by referring to an arrangement whose just get the wording right, an arrangement whose object or effect is to make available aircraft, let's say, for use in Russia, is it's a description of the nature of the arrangement.
So your position then is that the nature of the arrangement as a scheme whose object or effect is to make aircraft available in Russia is fixed at the date of the arrangement, i.e. the lease. Is that right? And that
yes.
There is then a separate question, which no doubt you'll address, whether that is an arrangement for restricted goods, given that aircraft weren't restricted at the time.
Yes, if I may just qualify that. It is in a sense fixed at the date of the arrangement, because you are asking the question by reference to what the arrangement is. Of course, you wouldn't need to consider that point until the 1st of March 2022, because prior to the 1st of March 2022, there was no sanction in connection with those kind of arrangements, and therefore there will be no reason to ask that question. But once the sanctions come into force, they describe a particular category of arrangement in connection with which payments are not permitted. Having described the nature of the arrangement, of course, in order to decide whether the sanction applies, one has to ask whether the lease, in this case, is such an arrangement.
So, is this right? Take an extreme example, perhaps, but if you had an aircraft lease, a short aircraft lease for an aircraft to be used to fly to and from Russia, pre-sanctions,
yes.
The lease expires through effluxion of time. The aircraft's back in the UK, but deferred payment is then due. Are you saying that's caught? So the lease is over and done with, the plane flew to Russia, came back, but the payment is deferred and is sought. Are you saying that's caught?
Yes, I mean that's obviously an extreme example.
Well, that's how I put it. I just want to see
and
where we go.
It is an extreme example. And one of the points I will be going on to make is the use of extreme examples to indicate some absurdity or unfairness in the...
Well, it may be unhelpful, but what's the answer?
The answer to whether it's covered, the answer is yes, it would be covered, because that is an arrangement which has the purpose of...
Even if at the time that the aircraft lease was in operation and the aircraft flew to and from Russia, that it was not a restricted good.
Yes, because one's asking the question whether it's a restricted good, in other words, whether it's an arrangement.
Well, on my hypothesis, it wasn't at the time. It's just a payment; it's a deferred payment.
Right, but one is asking the question about the nature of the arrangement as at 1st of March 2022 when this regulation comes into force. And at that point, the fact that there may have been no restrictions of any kind on these arrangements pre-1st of March 2022 is, in my submission, not the right question. One has to ask this question at the point at which a party is being required to form.
See, I can understand. You might say the difficulty is you're asking then to read Regulation 28.3, first of all, using the word was, and then you interpolating that you imagine that the time that the object or effect was for the use of the plane in Russia, that it was restricted goods when it wasn't. It does seem, it was a deliberately extreme example, but it does seem a little far-fetched to suggest that the sanctions regime was designed to catch and deferred payment at that time.
Well, first of all, with respect, I'm not saying that one has to read is as if it says was. What I'm saying is that the natural meaning of is in this context is that it's describing the arrangement. You might say an apple is a fruit. You're not attributing any. There's no sort of temporal aspect to that. It is a description of a kind of thing, and what this regulation is doing is describing a kind of arrangement.
Well, but at the time the arrangement was entered into, to pick up my Lord's question to you, and you accepted it, you were effectively freezing at the time the arrangement was entered into. It wasn't a restricted good. So why do you say it's court?
Because I mean, restricted goods in a sense. Well, in a sense, restricted goods is used as a defined term.
Yeah, I mean,
as defined in the regulation.
If I understand your argument, you can effectively cross out the word. It's just a definition that encompasses, among other things, aircraft. So the way you put your argument, just insert the word aircraft instead of the term restricted goods.
I was, as it happens, about to make exactly that point. I think if I may respectfully agree with that, because there is a slight risk of error here, that because the legislation has used the word restricted in the defined term, that one reads that as having a sort of general meaning.
You could say widgets, and then have a definition of widgets,
I mean, you didn't take
aircraft.
us to it, but it actually might be quite helpful to go to how restricted goods is defined.
Yeah, it's
it's a bit complicated, I know.
It is. Let's get the reference. 77. Yeah.
I'm not sure we've got all the...
Oh, sorry, it's page 77 of the bundle. Page 77. It's in section 21, regulation 21, and do you see in the middle of page 77, restricted goods means critical industry goods, dual-use goods, military goods, and then what was added in F16, aviation and space goods, or refining goods, etc. So as a matter of interpretation.
I mean, it doesn't actually stop there, because aviation and space goods is then defined in a schedule.
Yes, I think it's defined as
all the relevant.
Yes, it's actually on page 73, aviation and space goods.
Those words were added, is this right, on the 8th of March 2022? So after termination of the constitutional lease.
I think what might assist me at least is to have because I don't think we got the full set.
Yeah.
The definition of aviation and space goods, which takes you to Schedule 2C, which I'm not sure the extracts that take us to
Yes.
the place where everyone agrees we are, that it includes civilian aircraft.
And I think there is
including as from the 1st of March.
I think the problem is that this, what we have in the bundle,
Yes.
is the current version.
Exactly.
And we don't, I'm afraid, have the version that was extant on the 1st of March 2022.
I think that would be helpful.
But I will check that. But I certainly understood that it was common ground that as at 1st of March 2022, the definition of restricted goods included, when one cycles through the definitions, aircraft. And therefore, as a matter of interpretation of the regulation, we do say that when one's looking at 28.3, and when, for example, in 28.3c it says directly or indirectly making restricted goods available, what that means is restricted goods as defined in the regulation, it shouldn't be read as meaning, for example, directly or indirectly making goods that were subject to any statutory restriction. And because restricted goods in 28.3 is simply being used as a convenient term to represent a set of goods, including aircraft. And that's why I say, and in fact, just going back to my sort of apple as a fruit example, what 28.3 or 28 is doing is describing the nature of the arrangement. It's not a temporal exercise at all. It's simply saying, well, what is the arrangement that we're concerned with? Is it an arrangement for making available restricted goods? And that doesn't involve the court or someone subject to the sanctions investigating what activities have or haven't yet been carried out under the arrangement. It's simply about what kind of arrangement it is. And in other words, if that's right, we say it plainly is, because an aircraft lease is an arrangement whose effect is to make available aircraft, then the letters of credit, as I showed you, were plainly issued in connection with the lease. And the letter of credit says so on its face. I showed you that reference. And the demand that was made in connection with an alleged breach of the lease, because again that was expressly set out in the demand, from which it follows that to transfer funds in accordance with the demand would have been to provide funds in connection with the lease.
Well, that submission doesn't, as I understand it, depend on the fact that the credit describes itself as being in connection with the lease. That's simply icing on your cake.
Absolutely, yes. It describes it as being connected with the lease because it is connected with the lease. That's just yes, icing on the cake. So and that exercise of paying, of transferring funds in connection with a qualifying arrangement, which we say this lease is what is prohibited by Regulation 28.
Well, the letter of credit may be connected with, to take up my Lord's point, the letter of credit in the general sense is connected, but the payment obligation is expressed to be independent.
But it's independent in the sense that the obligation to pay is not dependent on, for example, whether the lease has been performed or not.
Yeah, but I'm just trying to pick up my Lord's point that it's a bit double-edged for you to point at the words in connection with on the face of the document. The real question is whether it's in connection with as defined in Regulation 28.3, because if you look at the face of the document, the actual payment obligation is said to be independent. So, in a sense, the actual terms of on the face of the document could pull you in two directions, or could be said to be bootstrapping on your part. What we're really interested in is whether it's in connection with as defined in the regulation.
That's right. Although if I may just make this point, I think there's a difference between saying something's independent and saying it's unconnected. I think what we say is that the payment obligation is independent of the obligations under the lease. But they're obviously connected because the LC and the payments under it are given in order to secure effectively obligations under the lease.
Is the credit itself an arrangement whose effect is to make aircraft available for use in Russia? If you don't open the credit as the buyer of goods or the lessee of goods, you're not going to get them.
Well, we haven't obviously made that case, in that sense, there's obviously a point at which one the sort of causation chain stops, but the letter of credit itself, no, my submission is not an arrangement to make available aircraft. An arrangement to pay money against the demand. But that doesn't mean it can't be connected with such a perhaps I can take up that point by looking at what the judge said about this, because some of these points were raised in his judgment. If you were to have the judgment at tab 15 of the core bundle, his reason is at, or his conclusions are at paragraph 126, page 225 of the bundle. And he does this in a series of number of paragraphs, and I just perhaps just briefly run through them. 1261, he starts off by saying that he accepted the claimant's contention that the starting point is to identify the purpose of the regulation. So the purpose is clear. Plain the intention of the legislature was to ensure that financial assistance was not provided to Russian parties in relation to inter alia the supply of aircraft. Now, in my submission, that was too narrow an expression of the purpose. I've shown your lordships and your ladyship already the statutory purpose, which is recorded in Regulation 4, which was required to be recorded. It is much broader than that, and it is certainly not limited, as the judge seems to suggest, to situations where financial assistance is provided to Russian parties.
Well, I thought you took a more fundamental point, which is that the judge has got the wrong starting point, which should be the terms of the regulation rather than anything else.
Well, quite. I mean, of course, one has to look at the legislative purpose to interpret statutes, but one mustn't, as I guess the judge may have done, fall into the error of treating the purpose of the purpose of the statute as superseding its express terms. I mean, the purpose may help you in the interpretation, but it doesn't limit or define the scope of specific provision. I mean, there's just one authority I might just show you on, I'm sure it's very familiar, but there's one authority on statutory interpretation which we might just look at, which is tab 37 of the authorities bundle. Queen again, Secretary of State for the Home Department. And you find it beginning at page 1012 of the authorities bundle. And the relevant passage I have at 1028 in the judgment on the judgment of Hodge. And perhaps I can just ask your lordship just to cast your eye over paragraph 29 and 31, which correctly state the approach in my submission.
So 31.
31, yeah. Now, it may be said, I think it is said, that on the facts of this particular case, since we've got lessors that are Irish and German companies, a prohibition against UniCredit paying under the LCs would not in fact have any influence on Russia's conduct in the Ukraine. And to that extent, it might be said, doesn't further the stated purpose. But, as I say, it will be erroneous to proceed on the basis that the purpose should be treated as a test. In other words, if there are activities that fall outside, that don't in fact further the purpose, the statutory purpose, they must be outside the scope of the sanctions. Because, and this is a point we make in our skeleton at paragraph 12, sanctions particularly are a blunt instrument intended to have a broad impact and to anticipate a range of potentially undesirable activities. They are inevitably, and one sees this in some of the material that was issued with the regulations, that sanctions are focused on larger policy objectives and not on the circumstances or equity of particular cases. And so, in my submission, there's nothing surprising or objectionable in the fact that the sanction may be drafted in such a way that in some cases it might go further, with the benefit of hindsight, than might be strictly required to meet the legislative purpose. And that, of course, is there where it becomes relevant to say that to the extent that there is any excessive bluntness in the application of a statute in a particular case, that is tempered by the existence of the licensing regime, because it allows otherwise sanctioned activities to be permitted. And that is a point that was specifically made. If we can go to page 156 of the authorities bundle.
Which tab?
So it is tab. I think it's tab 6 is where the document starts, and this is the report on the purposes of the regulations, which the relevant minister was required to provide when the regulations were originally made.
I think you should just for the legislation, but what stage is this as far as work is the report required to be provided under the statute?
Yeah.
But nothing more than that.
It is an aid to interpretation in the sense that it is a document which the minister is required to, as part of the statutory regime, required to prepare in order to explain the purposes of the regulations. So to the extent that one is looking at purposes, this is an aid to understanding what they are.
Would you put it in a similar category to, say, explanatory notes? Or
Yes.
Something different. So explanatory notes conventionally used to help demonstrate mischief,
Yes.
but not a great deal more than that.
That's right, yes. So, I mean, there's
It's a report, is it, which is contemporary with the Act, or is it after the Act?
I think it's contemporary with the regulations, because if you go back,
the regulation.
yes. So, or rather, I should say, contemporary with the original regulation.
So what does Section 18 actually say?
Section,
Because it's not in the bundle.
sorry, Section 2.4.
Tab 6.
We're at tab 6. Section 18 is another kind of report.
Sorry, okay. So we're at tab 6.
We're at tab 6, and I think you can see what Section 2.4 requires in paragraph 1 on page 153. It's a report under Section 2.4, which Section 2.4 requires a report to be laid before Parliament, explaining why the minister considers the purposes meet one or more of the conditions. So that's why it was produced, and it was produced in 2019, so it's obviously pre the current. And the only think the only point that I rely on it for, and you may say, in the end, it's
well, I could make the same. I could ask just. Sorry,
yeah.
I'm not trying to make a point. I'll just ask the same question because unfortunately, Section 2 doesn't appear in our bundle either.
No, I'm sorry about that. But it is. I think the effect of it is, as I say, described in the first paragraph.
But as my lady was trying to put to you, I mean, is this just really reporting to Parliament?
Yeah.
You say that has the same. What's the purpose of it? Is it to explain to Parliament how the Minister has exercised the delegated powers?
Yes, because he only has the power to make regulations if they satisfy the purposes described in the primary legislation. And the purpose of this report is to explain what the purposes of the secondary legislation are and how they fall within the overall purpose.
So it's more a why, not what report. I mean, it's saying why it's being done, but not why is it an aid to interpretation of what has been done.
Well, I think it's why the Minister considers that the purposes are appropriate. So to the extent that it's...
I mean, I know it must encompass what to some extent, but it's not really focusing on the wording, is it?
No, it's not focusing on the wording. And indeed, this obviously was produced before the wording that we're concerned with. And I mean, the only passage that we've relied on our skeleton that's really relevant to this is, and my submission maybe thought to be obvious anyway, is that it describes the purpose of the licensing regime in paragraph page 156, 3 paragraphs from the top. Where it says the trade measures and the regulations are targeted and provide for trade sanctions to be subject to a licensing framework. Power to grant licenses under this regime supports the reasonableness of imposing these sanction measures as it will mitigate any unintended negative consequences. I mean, you may think that doesn't, in a sense, that doesn't really take things that much further, because we would say that's obviously the purpose of a licensing regime. In other words, to allow some things to be done that otherwise wouldn't be done. And one reason for granting a license might well be to mitigate unintended negative consequences. So, I mean, perhaps if I can put it this way, the key submission I'm making here is that when one comes to look at the interpretation of Regulation 28.3, and in particular when one looks to the extent that it's permissible to do so, at the purpose or mischief of those regulations, one must have in mind that unlike many pieces of legislation, the sanctions are not absolutely fixed in stone, because there's always a possibility to apply for a license.
Maybe I've missed it somewhere, but at some point I'd like personally to understand, speak for myself, whether the licensing regime is designed to cover both licensing of activities which are definitely caught, or the avoidance of doubt licensing activities which are not caught, but people might be worried could be caught. So in other words, does the licensing regime only operate so as to validate those things which are definitely caught and would otherwise be unlawful, or are the licenses granted in circumstances where the matters are not caught, but somebody has made an application and a license is granted rather than being told you're not caught, we're not giving you a license, but you can take it from us, you're not caught. How does it work?
Well, so from a legislative perspective, the legislation does not contemplate a kind of protective license, if I can put it that way. the legislation, and this is really paragraph regulation 65, which I think I've taken before, simply says that the prohibitions do not apply to anything done under a license. So far as the statute is concerned, all that is said is, if it would otherwise be prohibited, it can be licensed. There's nothing, so far as I'm aware, in the scheme to allow for a kind of advisory license or a protective license.
Well, I mean, that's the issue. Suppose somebody thinks they may be caught. They apply for a license. Do the licensing authorities say, we take the view you're not caught, therefore we're not giving you a license? And are they then protected against somebody subsequently saying, actually you were? Is there some provision to deal with that situation?
Well, no, except to the extent that Section 44 applies. So the protection that the legislation gives you is if you reasonably believe that you were, sorry, that's protection the other way around, of course, isn't it? Your Lordship's asking about if you act and then it turns out to be a breach of sanction, whether it would be defence to say that we
applied for a licence, we were told we weren't caught.
So, as far as I'm aware, the legislation does not provide anyone with that protection.
I mean, maybe this will be more relevant under issue 2, but
I think it probably. And to be clear, I should make this clear. I'm not saying on the regulation 28 point that the fact that a licence was issued necessarily means that there would otherwise have been a breach of sanction. In other words, I'm not saying that the licensing bodies make a determination which is binding on this court as to whether something was or wasn't.
and hence my question, read in reverse.
Right. It may well be relevant when it comes to Section 44, but I'm not suggesting that the fact a licence was issued is determinative of the points we're debating now. On the other hand, it's right to say that the legislation contemplates, or only contemplates, that a licence will be given in order to license something that would otherwise be prohibited, and does not suggest any regime for advice or protective licences or anything of that nature. Right. Can I just go back to the judgment which we were looking at in page 225 of the bundle. I think I made the point I wanted to make about purposes and the relevance of licensing. Sub 2 on page 226, the judge made the point that the regulations would normally be expected operated prospectively and not retrospectively. We wouldn't disagree with that as a general proposition, but one needs, in my submission, to be a little bit careful about what we mean by prospective and retrospective legislation when one normally uses those terms. Clearly, the regulations operate prospectively in that they make unlawful only things that were done after the date when the regulations come into force. So we're not suggesting that they have retrospective effect in the sense that they can make something that was lawful when it was done into an unlawful act. Because clearly that kind of retrospective criminal legislation would be inappropriate. And so the judge goes on to say, he says, well, therefore look to the time at which financial assistance was provided to the relevant party. Well, that's right, although to be clear, what we're concerned with is not the provision of financial assistance, but the provision of funds. And then he says here, the issuance of a letter of credit to enable the supply of aircraft to a Russian party after the date at which the regulations came into force would plainly come within the prohibition, as both parties accepted, and in my submission that's obvious. And again, the retrospectivity principle would mean that the issuance of a letter of credit before 1st of March 2022 wouldn't retrospectively become unlawful. But that doesn't answer the question as to whether it's unlawful after the 1st of March 2022 to make a payment of funds under that letter of credit. Paragraph 3, the judge then says, that's not the case. Here the aircraft have been supplied long before the prohibition came into effect, at a time where it was perfectly lawful to make such a supply. But that's true. And likewise, the provision by UniCredit of financial services was made when they issued the letter of credit, which served as a mechanism for the satisfaction of payment obligations. And again, at the time of the provision of the services, that provision was perfectly lawful, and that's also true. The problem with the reasoning here is really at section 4, where the judge says all that remained to be done, as at the time that the prohibition in Regulation 28 came into effect, was for the obligation undertaken long before, to be fulfilled. And that's UniCredit's obligation. The fulfilment of that obligation benefited the claimant. Although this fulfilment may also have the collateral result of discharging the independent obligations of the lessees and spare bank towards the claimants, that was a wholly collateral matter. Moreover, because UniCredit remained able to claim against spare bank were not benefited, and nor were the lessees, since they remain liable to spare bank. Now, in my submission, the problem we're looking at it that way is that the judge has not really asked himself the direct question raised by the regulation, which is whether the provision of funds, or the proposed provision of funds, was connected with a relevant arrangement, we say with the lease agreement. What he seems to be doing here is considering two different questions. The first of which is whether the obligation to pay money by UniCredit was a pre-existing obligation, because it related to when the LC was issued. And the second question is whether the provision of funds by UniCredit would benefit any Russian parties. And neither of those matters, in my submission, are conditions for the application of the regulation. And if I can just deal briefly with those 2 points. First of all, Regulation 28 says nothing about existing obligation. If it had been intended that the prohibition on the provision of funds should not apply to existing obligations, then the regulation could have said so. And we make the point in our skeleton that other similar regulations, in particular the Syria regulations, sanctions, and the Belarus sanctions, do both have exceptions for pre-existing obligations. I'll just give you the references. It's paragraph 48.4 of the Belarus sanctions. Sorry, that's so regulation 15C sub 5 of the Belarus sanctions at tab 2, page 62. And we don't need the reference, there's a very similar carve out in the Syria sanctions as well, both in relation to insurance. So the idea of having a carve out for pre-existing obligations is recognised in other sanctions. It's also, and perhaps we can turn this one up, in the EU regulations on which these 2019 regulations were based. If we go to tab 10 of the authorities, we go to page 301. These are the EU regulations on prohibited goods. You see that in Article 5, page 301, the prohibitions shall not apply to the execution up to until 28th of March 2022 of contracts concluded before the 26th of February 2022 or ancillary contracts necessary for the execution of such contracts. So the EU regulations have a limited permission, a limited exception for the prohibitions in relation to pre-existing obligations.
What does that mean?
It means that up until the 28th of March 2022, you can continue to supply goods, execute contract. Sorry.
Does it mean
continue to supply goods if the contract was concluded before the 26th of February.
to the execution of contracts?
Yes, that execution is, Roger is right, it's a slightly odd word.
Does it mean
Meaning performance.
I think it must mean performance, because it's in the context of a prohibition on various activities, including aircraft activities.
So until the 28th of March 2022, you can perform a contract concluded before the 26th of February 2022.
Yeah. But of course, after the 28th of March 2022, you can't. Even though it would be might well be a pre-existing obligation. So you have a sort of honeymoon period where you can continue performing your existing obligations, and thereafter you're stuck. And there is so that's how it's dealt with in the EU regulation, and there is a similar concept in the UK licensing regime, because if you go to Authorities Bundle 8, tab 8.
Sorry, so how does this bear on the interpretation of our Regulation 28?
Well, I'm simply saying that, that there are a number of regulations, both EU and English, where the possibility of a party being subject to pre-existing obligations and how that would affect the sanctions has been expressly dealt with. And for the judge, therefore, to say, well, this sanction can't apply to pre-existing obligations, in the absence of any wording to that effect, there's really no reason to make that assumption.
But is this EU wording something which the maker of our regulation is supposed to have had in mind, or not? I mean, does it even come before our regulation?
Yeah, I mean, these were all issued essentially at the same time for the sort of common purpose against Russia. So, I mean, to that extent, it shows how the EU did it. But I'm just going to say, I mean, it's also reflected, this same honeymoon period, if I can put it that way, is reflected in the UK licensing regime. Because if you go to tab 8 of the Authorities Bundle, you'll see another document issued under SAMLA, and that's a guidance document. And just to explain what this we do have in the bundle, it's issued pursuant to Section 43 of SAMLA, and Section 43 says that the minister, when he makes regulations, must issue guidance about prohibitions, including best practice enforcement and circumstances where they don't apply. And so far as relevant to the present discussion, if you go to page 233 of the bundle, first of all, if you go to page 210 of the bundle, you'll see there's a section in the guidance about licensing. Licenses may also be issued for certain trade activities that would otherwise be prohibited by the regulations. I don't know if that goes some way to answering my Lord Justice Snowden's point before about the scope of licensing. But if you go down to 233, there are various examples of situations in which licenses will be granted. And at 233, you see prohibitions on the provision of technical assistance, etc., relating to aviation. A license may be granted for various things, including the provision of funds, if necessary for the execution of obligations arising from contracts concluded before the 8th of March 2022, or ancillary contracts necessary for the execution of such contracts, provided that the activity is completed before the 28th of March 2022.
And execution we seem to have followed one way or other.
Yes.
But the date of 28th of March is also also the same
as the
in
EU one.
regulation.
So
although the licensing authority would have to work at great speed for that to be of any use.
yes, it would, because it's a very limited.
Yes.
Whether it could, I don't know. But obviously, the short point we make on this is that this would be essentially redundant if the judge was right that pre-existing obligations weren't anyway covered by the Section 28, Regulation 28, because this provides a.
Well, hang on. This is not redundant. I mean, it might apply to other cases.
Well, if it's right that Regulation 28 doesn't apply in relation to the execution of obligations arising from historical contracts, then you would never need a license for that, because it simply will be permitted. So this particular ground on which a license can be granted wouldn't be necessary, because you could simply say, well, my contract was concluded before the sanctions came into force, and therefore it can't be affected by the sanctions. That's the point I make on this.
I mean, it assumes, presumably, that the contract concluded before the 8th of March 2022 was for what is now a restricted good,
yes,
but was not then.
Yes.
Because if it had been then, you couldn't have made it
quite
in the first place.
Quite. And it's understandable in circumstances where the regulation on the face of it is bringing in prohibitions in relation, we say, to things that were lawful at the time they were done. And one can see the possibility of unfairness for someone who says, well, I entered into this contract when it was lawful, but now on the face of it, the sanctions are telling me I can't perform it. The answer, the sort of regulatory scheme answer, is to say, well, you have a limited ability to seek a license, but if once the time's expired, well, you're struck with a sanction. So that's in my respectful submission, not a relevant consideration. The judge, with respect, was wrong to say that it was. And his second point, which is that the arrangement we are talking about, if funds were provided, would not result in any benefit to Russian parties. Again, that may well be right, but that's again is not a relevant criterion imposed by the regulation. At least not under 28.3 C2. There are other parts of the regulation, in particular Regulation 28.1, which do address directly the provision of financial services, for example, in relation to persons connected with Russia. So there are other parts of the regulation which are concerned with whether or not a Russian person, a Russian-connected person, is receiving a benefit. But that's not a condition to the operation of 28 sub 3 C2. And indeed, the very fact that other parts of the regulation do deal with benefits to Russian persons indicates that 28.3 C2 is dealing with something broader than that. So the two reasons or the two questions that the judge asked himself in paragraph 1264 on page 226 of the full bundle are both, in my respectful submission, the wrong questions to ask. He should have been the question he should have been asking himself is one of connection, because that, certainly as he's been told by the claimants, but also by UniCredit, was the key issue. And it's striking in a way that paragraph 126 doesn't actually refer at all to the question of connection. It uses regulation. The judge does in sub 5 on 226, page 226, go on to refer to the autonomy principle. And clearly, you can see from the judgment, the claimants put a significant reliance on the autonomy principle below, as they do here, and the judge obviously thought that was important. But in my submission, the autonomy principle here is a red herring. When we say that a lessee is an autonomous obligation, we mean no more and no less than that the bank's obligation to pay the beneficiary is separate from and unaffected by the performance of other contracts between the parties. And in particular, it's autonomous in the sense that the bank cannot take into account in deciding whether to pay or not any matters other than the facial performance of the demand. So, to that extent, and again returning to the point that Justice Snowden raised earlier, it is an independent obligation. But that's not the question we're concerned with on this appeal. We're not concerned as whether it was independent in that sense from the lease, but whether there was a connection between the lease and the letter of credit. And when, in my submission, one puts the question in that way, just to clarify, the particular connection we're looking for here is a connection between the payment of the funds and the lease, which we say is the relevant arrangement. And in my submission, there obviously is a connection, because the credit is given and the funds are paid as a form of support or security for the lease contract. I mean, that's why the LC has been issued, and that's why, I appreciate this is perhaps not determinative, but that's why the LC says on its face that it's connected with the provision of the lease, and why the demand is required to state that there has been a default under the lease. I mean, the two things are, in that sense, completely intertwined. And that's not in any way inconsistent with the obligations being autonomous. I mean, one can actually, one can perhaps even see this from, I think that the judge referred to the relevant provision in the UCP, Uniform Customs and Practice, which we have at tab 52 of the authorities bundle, which sort of reflect autonomy in the UCP sense. We go to page 1416 of the bundle. We'll see how the UCP reflects autonomy. It's Article 4A. Credit, by its nature, is a separate transaction from the sale of other contracts on which it may be based. Banks are in no way concerned with or bound by such a contract, etc., etc. Consequently, the undertaking of the bank to honour and negotiate or to fulfil any obligation under the credit is not subject to claims or defences by the applicant, resulting from its relationship with the issuing bank or the beneficiary. So that's what autonomy means. But even
you would say, I suppose, that if, as the first sentence of Article 4 says, a credit is based on,
you have again anticipated. Very good. So, I mean, again, it's not a, my submission, it's not a very sophisticated point, but I mean, the whole point of LCs is to provide a form of payment security in relation to some other underlying contract from which it is separate and independent, but with which it is connected. So the judge's reliance on autonomy, I suggest respectfully, was misplaced. Just picking up the final 2 points the judge made in the judgment is paragraphs 127, 128. He said, paragraph 127, he said, I also accept the claimant's submission it's important to take a step back in this regard and ask whether the fulfilment of an independent obligation owed by a German bank to Irish companies can be said to benefit the Russian entities who happen to be involved in other elements of the overall transaction. In my judgment, the answer to this question is quite clear. It cannot. With respect to the judge, that's not a correct approach. It suggests that in some way, I mean, talking about stepping back, the judge is really looking at the question as being one of overall fairness on the facts of this particular case. In other words, is it, because these companies are not related to Russia, is it really fair?
You say that's dealt with by the licensing regime. In other words, you say it's court, but those sort of considerations would come in under the sort of decision as to whether to grant a license.
Yes, that's only one point I would make. I would make a slightly broader point. So when one starts in the analysis, I suggest what the judge appears to be doing here is saying, well, let's start with the purpose. Purpose is to discourage Russia from invading Ukraine. And let's, having taken that as a purpose, let's look to see whether what's happening here really furthers that purpose one way or the other when one steps back from it. In my submission, the starting point really should be the words of the regulation.
He's right, isn't he, in what he says in 127? It's just that you say it's not the relevant question. I mean, it is a bit odd that sanctions designed to put pressure on Russia should prevent this this payment from being made, which doesn't do Russia any good at all.
I say odd. I would say it could be argued that it results in a difficult consequence in this case, but it's not odd in the consequence of when one looks at the sort of sanction regime as a whole, and one sees the breadth of the policy that one's trying to implement here. If I can put it this way, the larger forces are at work here, and it is not odd in circumstances where there's a larger policy objective that will result in, if I can put it this way, some collateral legal damage along the way, because that is the way in which the UK government has decided it wants to further its larger policy objective. And the answer to the question of saying, well, that may visit unfairness in individual cases is then the licensing regime. So I suggest that, of course, if one, and this I suggest is perhaps an error the judge was making, if one focuses on the facts of this particular case, then of course one can say, well, it seems odd that someone who's got nothing to do with Russia is finding themselves in a position where they become tangled up in Russian sanctions. But if one asks the question, well, starting from the overall purpose, which is a very broad one, which is to and which necessarily has to anticipate all sorts of scenarios which can't necessarily, particularly when the regulation comes about. With that wider policy objective, is it odd that there are some hard cases? In my submission, no. And the answer to those hard cases is the licensing regime. So to that extent, you're right. It may be odd if you look at the particular facts, but that's not the correct way. That's not the exercise that the court should be engaged in interpreting the sanction. And then he goes on to deal with licensing at paragraph 128, where he says that he doesn't accept our submission. The regulation should be read broadly on the basis that any vagaries that such a reading might lead to can be assuaged by the use of the licensing system. He said the extracts from the guidance seem to militate against such an approach. These extracts suggest that the licensing authorities may take the view that prohibited transactions may nonetheless be licensed if they're thought to be consistent with the aims of the sanctions. But that in turn indicates that the license may be granted in relation to transactions even though they are prohibited on a proper reading of the sanctions. Well, we agree with that. I mean, that's the whole point we're making, that there are transactions that are prohibited on a proper reading of the sanctions, but might nonetheless be licensed. Where we disagree with what the judge's final conclusion seemed to be, that the sanctions should be regarded as all-embracing, subject only to the licensing regime. I mean, we're not saying that they should be all-embracing. The scope of the sanctions is determined by the terms in which they're drafted, except that. What we're saying is, to the extent that it might be said against us, that the interpretation of the license for which we argue is unrealistic in some way because of the oddity, the kind of oddity that we were just discussing. That is not in itself, as it might be in other legislative contexts, that is not in itself a reason to read down the drafting of the sanction, because you do have, as you don't have in those legislative contexts, the escape valve of licensing.
So, I mean, you'd say, that's right, I mean, it's not strictly speaking in guidance, but it was that paragraph in one of the reports you took us to.
Yes.
Authorities Bundle, page 156,
yes.
where the report to the power to grant licences supports the reasonableness of imposing the sanctions measures as it will mitigate any unintended negative consequences. I mean, stripping all the wording out, you're basically just saying that if you throw your net too widely and inadvertently catch something that doesn't serve the sanctions purpose, the licensing regime is the answer.
Yeah, that's right. And indeed, I would have said that even without the guidance, because I would say that's an obvious consequence of the licensing regime in this situation, that the guidance confirms that. And as I say, one has to look at, in terms of sort of throwing nets, one starts from the sort of very broad policy objective, which in this kind of situation, one can understand why the net is thrown very widely. There might be other policy situations, legislative situations, where the court can start from the perspective of assuming that the government would expect to be having a rather small net. But the breadth of the overall purpose suggests a large net. The larger the net, the greater the possibility you might catch unintended fish. And as I say, but tempered by the fact that you have the opportunity, as it were, to throw them back by through the licensing regime, and that forms a kind of balance. Of course, all that takes you back to the wording of the regulations. I accept that, but I suggest that to say, well, look at how it's turned out here. Isn't this unfair that a German company and an Irish company should end up in a situation where they have to wait for us to apply for a license, or they have to apply for a license? The answer is, well, that's not the right question. That's a consequence of the overall policy objective.
Right. Is that ground one? Or,
sorry?
Is that ground one done? Or?
That is, I think, ground one done. Yes. Just before I... No, I'll leave that. If there are any other points in ground one, I'll deal with them in reply. Can I then move on to ground two? Which is section 44 point. This point obviously only arises on the assumption that I'm wrong about Regulation 28, and it did not prohibit repayment. And then if we can look, please, at section 44, which is at page 32 of the authorities bundle. Protection of acts done for the purposes of compliance. 44.1, this section applies to an act done in the reasonable belief the act is in compliance with regulations under section 1, which includes regulation 28. And in those circumstances, if that condition is satisfied, the person is not liable to any civil proceedings to which that person would, in the absence of this section, have been liable in respect of the act, which includes an omission, and would therefore include the omission to pay funds.
This, as you say, arises only if you're wrong on ground one.
Yeah.
Does its application therefore depend on whether we think you're obviously wrong on ground one, or whether you, as it were, come close but not quite?
Well, it may depend on that. It may also depend, to some extent, if I'm wrong about Regulation 28, why I'm wrong about ground one. Because you will have, well, I think perhaps have seen that many of the points that are taken against me on ground one are points raised by respondents' notice that were not advanced in the court below. and one certainly might think that it would be difficult for the claimants to criticise UniCredit for being unreasonable in its belief if that belief turned out to be wrong only because of points that were raised for the first time in the Court of Appeal. So there's that aspect to it. And there is also, yes, I mean, one has to ask the question, did we have a reasonable belief? And that must, I think, to some extent depend on how obviously wrong UniCredit was. Your Lordship will also have in mind, in this respect, that of course we are only here arguing the point because the court has given us permission to appeal on Regulation 28, finding at least at that stage that there was a real prospect of success on the argument. So at least at the application stage, presumably the court had not taken the view that we were obviously wrong, otherwise permission to appeal wouldn't have been granted.
Well, I'm not so sure about that.
Well, you may think that's a bit of a cheat, but I mean, ultimately one is...
You can't improve your section 44 ground by pointing to the grant of permission to appeal, I think is the point.
Well, if one of the questions that arises is the objective strength of the case as it would have appeared to UniCredit at the time when it made the payment, it is, in my submission, not wholly irrelevant that a court has subsequently said, looking at that argument, that it has a real prospect of success.
All right, well, let's move on to your next point.
And ultimately, before I get to, can I come back to the question of reasonable? I'd like to deal with it, if I may, in the order that the judge dealt with it, because it's probably
yes.
easier. Because the judge broke it down into two points, one of which was so the first point was, did we actually believe, did we in fact believe that we were not entitled to pay as a result of the sanctions? And the judge was satisfied that we did subjectively believe that, but that is now challenged on this appeal. Can I just, in relation to that, I think perhaps the simplest way of doing it is, we say the judge was obviously right. Can I just show you the relevant evidence, just so you have it in mind, which covers the question of what UniCredit actually believed at the time? And it's all in the supplementary bundle. Let me just identify. First of all, there are two documents. One is at tab 29, which is a letter from RPC, UniCredit's solicitors, dated 11th of March 2022, which stated at paragraph 6 that it appeared to them that for UniCredit to pay the client under the letter of credit would be to breach the prohibition of making funds available in connection with an arrangement whose object or effect was to make restricted goods available. So RPC, presumably on instructions, were setting out what they understood the position to be, and that is consistent also with what UniCredit had itself said directly to the claimants, and one sees that in the next tab 30, in a long email chain, but the relevant email is at page 194, and that's dated 17th of March from Mr Marsman at UniCredit, responding to the demand for payment. And you'll see over the page at page 195, he himself also says, and this is about 4 paragraphs down, based on the information available to us, in the sanctions position at the time of writing, it appears, well, your Lordship can see what he said. And he says if that's correct, it would be a breach of English sanctions for us to receive or make payments under the letter of credit. And one I think should only right to infer that Mr Marsman and RPC are saying this because they believe it was right at the time.
Well, that's the 17th of March.
That is the 17th of March, yes.
The one on the 8th of...
Yeah, 29th, yeah. Tab 29, 11th of March.
RPC was the 11th of March.
Yeah.
So I'm just trying. You took us to the point. Remember, I asked you about the correspondence that had preceded
Yes. Yes.
points of claim. I'm just trying to locate that.
Well, I think on this. I mean, so far as while we've got this letter open, tab 29, it's just worth noting a number of points. First of all, I showed you paragraph 6 already. Paragraph 8 also refers to the consequence of the lease being terminated and explains the view at the end of paragraph 8 of the termination of the lease is not an answer to the problem. That's rightly or wrongly, that was a view expressed. And then paragraph 9 mentions licensing. Your client will no doubt be considering its own decision regulations in order for UniCredit to keep its position under review and to consider what appropriate steps should be taken, including potential license applications. Please provide the following materials. That seems to be that's the sort of outset of the discussions about licensing. And it's worth noting, of course, and this perhaps goes back to the point I made before about the dangers of requiring someone in the position of UniCredit to focus on the terms of the leases and what's actually been done under the leases, because UniCredit wouldn't have the leases and wouldn't know what had happened. And you can see that in order to make a license application, RPC is having to ask for various documents, including the terms of the leases themselves, 9.4, the location of the aircraft, who's in possession of them, and so on and so forth, for the purpose of the licensing application, which, just to revert to a point I made before, underlines the importance for the purposes of certainty of not imposing on someone like UniCredit a need to investigate whether the arrangements have been carried out or not, whether they've been partially carried out, and what the rights and obligations of the parties are under it, because it just wouldn't know. And you can see that UniCredit is having to ask for material.
I mean, it may not matter, but this is the letter referred to in paragraph 14 of the points of claim.
Yes.
But it was preceded by a letter from Mr. Marsman, the defendant, of the 7th, an email, sorry, on the 7th of March 2022.
Yes. I'm afraid I don't think we have that in the.
It's not one of the. It doesn't look like it's in the chain.
No, and I did look for that. Okay. So that's at least what's in the bundle. We've got those two letters. We've then got was also before the judge witness evidence from Mr. Marsman and also from others and from it's given at RPC. Again, just to identify those, if you go to tab 2 of the supplementary bundle. First of all, this is evidence of this given of RPC. She explains the source of her knowledge in paragraph 8.2 on page 24, where she says that she refers to the fact that there are various, as one might expect, understandings and decisions internally in different teams of UniCredit. And so she says there's accordingly no single individual within UniCredit who is able to speak to all of these matters. And that's why she's addressing it as a legal representative. And then she deals with the particular point of paragraph 11 on page 25, where she says UniCredit's understanding is that it became a criminal offence for UniCredit to pay Celestial from the 1st of March 2022. So that's she also deals. Yeah, so that's that evidence before the judge. There is also at tab 3 the evidence of Ms Foster, who is the head of financial crime compliance at UniCredit. And she, at paragraph 6, first of all, confirms what Ms Given said. And at paragraph 23 and 24 on page 53, she deals with the kind of analysis process within UniCredit and how that developed, and the way in which UniCredit eventually reached the view that Regulation 28, which he says at the end of paragraph 24, Regulation 28 prevented payments under the LCs. And again, just for completeness, the point is also dealt with by Mr Marsman himself in his witness statement at tab 4 at paragraph 16. Now, there was no cross-examination of those witnesses.
Sorry, Mr Marsman's statement, not giving a reference.
Yes, so the statement begins at tab 4, and the relevant paragraph is at paragraph 16, where he says the financial sanctions compliance team came to the conclusion the bank will be in breach of sanctions.
The email,
yeah,
presumably referred to in the pleading, is the one which is at pages 1 to 3 of the exhibit to Ms Given's witness statement, is it?
Yes, but I'm afraid it's not in the bundle. I'm sure we can get hold of that.
Yeah.
So, as I say, there was no request for cross-examination of those witnesses. There was no reason to, the judge not to. No reason for the judge not to accept their evidence as it was given, and not to accept UniCredit's case that it did believe that the sanctions applied. And indeed, one might perhaps ask the question: UniCredit didn't actually believe the sanctions applied. What are we doing here? But ultimately, it's a question for the judge to decide on the witness statements, and he was right to take them at face value. So that deals with that actual belief, and then when we come back to the question of whether the belief was reasonable, and
in fact, the thing that I don't think you may not, my note doesn't repeat this, but it's Miss Given's statement, paragraph 33 seems to be the one that everybody refers to.
Yes, sorry, did I not give you that reference?
You may have done, sorry, I just didn't write it down, is that right?
That's correct, yes. UniCredit was concerned that payments under the LCs would contravene the provisions of Reg 28.
Which, and 33 and 34, so it's sort of raised as a concern, but again, there's a reference there to the email.
Yes. And Ms Given's obviously the solicitor in the case, but also just to note in para 6 of Ms Foster's evidence at tab 3, she confirms what Ms Given said. I think the complexity in giving the evidence is, as one might expect, this particular issue was debated extensively within UniCredit by different people. And it may well be that not everyone had the same view about it, but eventually they reached a consensus, and that's what's reflected in the evidence. Reverting to the question of whether that belief was reasonable, and perhaps just going back to my Lord Justice Mayles' question. Obviously, you already have my submissions on what Regulation 28 actually means. And obviously, in the alternative, I would say that even if, contrary to my primary case, you don't accept I'm right about that, they are at least reasonable arguments. And if UniCredit actually believed that they were within the scope of the sanctions, that was a reasonable belief, based on the arguments and considerations that we've been.
Well, I mean, there are two different points, aren't there? Because occasionally people shockingly ask their lawyers to argue something which may be reasonable or which they don't believe.
That's correct. But
we need to focus on belief rather than arguments.
That's correct. But it's also right, I suggest, to split it into first subjective belief, as a judge did, and we approach this second point on the basis that the court, the assumption that the court has found that UniCredit did in fact believe that they were subject to these sanctions. Because if they didn't believe that, we don't need to go any further. So we then ask the question: well, if they did believe it, was that a reasonable belief? That's an objective question. And I would suggest it is equivalent to the question of whether there were reasonable grounds for that belief. And it's in that context that one has to look at in a slightly unusual situation where the thing you're believing in is ultimately a question of law, not a question of fact. One does, I think, have to look at the arguments for and against that position, because if it could be seen by any person in the position of UniCredit to be an obviously untenable position, then the court might conclude that the belief was not reasonable. But if
just sticking with the question of subjective belief, the judge has made a finding.
Yes. So
what is the test on appeal in this court if we are to interfere with that finding?
Well, I would suggest that he, having made a finding of fact, the court has to approach it on the basis that it is a finding that he couldn't have made on the evidence.
Okay.
We obviously say he was right to make it on the evidence, but we say it's sufficient for us to show that
yes,
it's one that he could properly make on the evidence. So reverting to the sort of reasonableness of the belief, as I say, it's a slightly unusual context for this because one's looking at essentially at what a party believe the state of the law to be. As I say, it must require some consideration of the arguments, because if you've got a legal position which is obviously untenable, and anyone would realise that, one can see that it might not be reasonable. But one must, of course, in looking at this question, look at it at the time when UniCredit was making the payment or non-payment. I think your lordship asked me, well, does this depend on whether the court finds I'm obviously wrong? In my submission, that wouldn't be quite the right way of approaching it, because, of course, lordship had, I hope, the benefit of a very extensive written oral argument from both sides on a point of law, with a lot of citation of authority and considerations of policy and so on. And sometimes, when we're all familiar with this process, the points that seem difficult at the start, after one's argued it out at length and thought about it carefully, coalesce in one's mind as being one side or the other. And the benefit of the process makes it seem simpler to the person who's having to make the decision. That, I think, would visit an unfairness in a party under Section 44 who has to make the decision at the time and without the benefit of, obviously they may well have the benefit of legal advice if they choose to take any, but they will not. It's not an issue that's been explored through the sort of rigour of litigation.
You're saying you measure the objective reasonableness of a view against the context in which the view was formed. In other words, it's what would a reasonable person have thought. So was the view which subjectively was held one which a reasonable person in that same position would have held at the time.
Yeah.
At the time, not with the benefit of hindsight looking back.
That must be right.
That's
my submission, and in my submission, it must be right because it is something that's intending to protect someone against an action that they are taking at a particular time. They're making a decision: should I do this? Should I not do this? They have to do that based on their view of their right to do so at the time. It's not much of a protection if they do it holding a reasonable belief at the time, with the benefit of a year's worth of litigation later and having read all the arguments from the parties, they may say, well, actually, perhaps that was wrong. But that can't be what Section 44 is aimed at protecting against. One has to look at it from the perspective of UniCredit or a person in UniCredit's position. One looks at it objectively, but one looks at it at the point at which the relevant act is done or omitted to be done. And we say when one applies that lens to it, one can perfectly reasonably believe, obviously we say it's right, but whether it's right or wrong, one can perfectly reasonably believe that when Regulation 28 talks about funds connected with an arrangement, the purpose or object of which is to supply aircraft, that means payment of an LC in connection with an aircraft lease agreement. Perfectly reasonable belief for UniCredit to have.
There's no equivalent defence, is there, to criminal proceedings?
Generally.
No, there's no equivalent to Section 44. Section 44 protects you from civil proceedings.
Yeah. Sorry.
But not from criminal proceedings.
That's correct.
From which it might be said that the purpose of Section 44 is to encourage people to err on the side of being caught by sanctions, because that protects them from civil proceedings if they reasonably get it wrong, whereas they have no protection from criminal proceedings if they decide they're not caught by sanctions, even if that's a reasonable view, but nevertheless go ahead and do something which is prohibited.
Well, one difference which may make the comparison not perhaps entirely apt is there would be a mens rea aspect of criminal proceedings, which there wouldn't be civil proceedings. Yes. Maybe the way I would say it, what Section 44 is perhaps effectively doing is importing some criminal law mens rea concepts into the civil proceedings. It would sound that certainly my position is that Section 44 is designed, as it says in the title, to protect people who are doing acts for the purpose of compliance with the sanction. Yes. So in other words, people who are purporting to, or who are doing things which they think are required by the sanctions, or else prohibited by the sanctions.
Yes, perhaps that's a more straightforward.
I think it's definitely that way around. It's intended to protect someone who, let's say, take this example, who has a contractual obligation to pay, but considers that not paying is required in order to comply with the sanctions. And it's saying that you are released from civil proceedings, or you have a defence of civil proceedings, if you have a reasonable belief in that respect. The reasons I've given in my submission, UniCredit did have an actual belief, and its belief was reasonable based on the various arguments that we've discussed today, and that's reasonable whether or not those arguments are found by the court.
Can I just ask you, the point's made against you that UniCredit hasn't shown its workings.
Yes.
What is your, I think, I want to clarify, your response to that is it doesn't need to. Once you've got past subjective belief, then it's an entirely objective test. So it doesn't depend, for example, on whether UniCredit might have formed its view on a particular reading or for a particular reason that may not be one of the reasons that you're now putting forward as reasonable. You say it doesn't matter,
No,
provided it's got the belief, then
It's got the belief, and then it's an objective question as to
you
whether
do not inquire what its actual thought process was in reaching that belief.
it's unnecessary to do that. I mean, to some extent, and I wouldn't necessarily accept the premise that we haven't shown our working, if you put it that way. I mean, we have. I understand that criticism is made, but we have gone to some length to explain how the process was debated within UniCredit.
Related to that is the point that is recorded as being made against you in paragraph 15.2 of the judgment, which is part of the claimant's arguments, which the judge then goes on to accept. And that is that your concern seemed in fact to be to protect your cash flow. Now, if we assume that the judge was right about that, and that was, as it were, an aspect of UniCredit acting unreasonably, and similarly, I suppose, the criticism that is made against you that you applied for licenses which covered both payments, not simply your own payment obligation. If UniCredit did act unreasonably in that way, how does that bear on the reasonableness of your belief that you were prevented from payment? Do you have any information about that?
My question is, it doesn't bear on. So the first point I would make is that the judge said that he thought that UniCredit was concerned about its cash flow. He didn't, however, think or find that the UniCredit holding that concern, if it did, negated its belief that actually it was prohibited by the sanctions from paying. One can perfectly well believe both things. I mean, in a sense, of course, they might have a concern about their cash flow, in the sense that if you're a confirming bank, you always have the risk that you will pay and not be reimbursed by your issuing bank, and in a sort of conflict situation, that's always going to be a concern. That's a different question from believing that you are. A different question from believing that you're caught by the sanction. What the judge didn't find, and what there isn't any evidence of, is that the reason, because this seems to be what the claimants are hinting at, but they don't say it, and the judge didn't say it either, is that the only reason that UniCredit didn't pay is because it wanted to be paid by Bank first, and it wasn't prepared to pay otherwise. That, of course, would be quite a serious allegation, a very serious allegation, because it would be essentially saying that UniCredit was deliberately refusing to pay on its independent confirmation. But there's certainly no inconsistency between being concerned about your cash flow, but also thinking that actually we can't pay because of the sanctions. And to answer your lordship's question directly, the Section 44 test is concerned with the specifically with your belief about whether or not you are subject to the sanction. That is what you are asking. Did you hold that belief? And if you held that belief, was that a reasonable belief to hold? And the fact that I mean, it's completely hypothetical, but the fact that you might have thought, well, actually, there's a collateral benefit to this because actually we won't have to chase Bank for money. That's not the question. The question is, did you in fact believe you were affected by the sanctions, and was that a reasonable belief?
Can I ask you just a slightly different point on Section 44? It applies to an omission done in, or an omission not done, or something not done in the reasonable belief that the omission is in compliance with the regulations.
Yes.
What's the omission here? Is it just not to pay full stop, or is it not to pay until you've applied for a license?
It is not paying because the regulation, at least on my submission on UniCredit's understanding, simply prevents you from paying.
Unless you have unless you get a license.
Right. So, because once you've got a license, then you would have to pay because Section 44 wouldn't.
So what I'm saying is it implicit in the protection you get under Section 44 that if you genuinely and reasonably believe, i.e. subjectively believe and reasonably believe that you're caught, is it implicit that you also have to get on and apply for a license?
No. Well, there's nothing, as far as I'm aware, in the legislation that puts the onus, as it were, on any particular person to apply for a license. I mean, in fact, in this case, UniCredit did, and we saw the correspondence from RPC.
Could either
Yes.
party of the
Yes, as I understand it, anyone can apply.
So it's no part of the reasonableness of your belief for the purpose of Section 44 that you have to go on and make an application for a license. You can, in fact, just say, we genuinely and reasonably believe we're caught by Regulation 28.3. That's it.
That's right. You have no.
I'm not saying it's wrong.
No.
I'm putting it. Sorry.
So
there isn't a big elephant trap around here.
No.
Okay? It's not that I'm aware of at the moment.
So to be good, so the answer is yes. If in fact the regulations prevent you from paying, or you reasonably believe they prevent you from paying, then that's the end of it. There isn't an implicit obligation that in order to rely on Section 44, you have to use reasonable endeavours to get a licence, for example. And that's not, as far as I know, been suggested by anyone. It wasn't part of the argument before. And I mean, there may be.
Mr. Justice Cockerell made a similar point, but that was in relation to US sanctions.
So,
and my lady's point would deal with that in any event. If the disappointed payee can apply for a license to be paid or for a fee, in a sense, then that you'd say supports your interpretation of that.
Yeah, that's correct. And indeed, I mean, RPC themselves pointed out to the claimants that they need to look to their own, their own position under the regulations as to what they can do. So
yes, but albeit that one of the letters we did see said that RPC were thinking about the paying. Was the point you made earlier that they were asking for information in order, amongst other things, to consider whether to make an application for a license.
Indeed, one might say that in some ways it would seem more natural for the claimants in this case to make the application because they are the ones who are able to say to the licensing authorities, well, look, these planes are no longer in Russia, so really this is not furthering the purpose. But I mean, as it happened in this case, it was done the other way around by UniCredit asking for that information and then making the application.
Right. Well, unless there's anything more on whether Section 44 applied, I think there are points against you that even if it applied, it doesn't help you so far as interest and costs are concerned. I don't know if you're going to move on to deal with them.
Yes, I do need to deal with those.
Right.
Yes, let me deal with those. First of all, on the basis of interest. To deal with interest and costs separately. And I think the first stage in the analysis is to recognise that the claim for interest arises because it's been pleaded. I showed you in tab 18 the form of the particular claim, which are in the normal form, and interest is a pleaded claim. And in both sets of claim. And there's a pleaded claim for debt, for damages. Perhaps let's just turn it up. 17 in this level of claim. Page 266.
And it's statutory, not contractual.
It is statutory, but it is statutory based on the allegation in 19 that there is a claim in debt and damages for the sum of $45 million. And our short point is that if Section 44 applies, then UniCredit is, as the section says, simply not liable to civil proceedings. It is not liable to civil proceedings in debt or in damages, and is not liable to civil proceedings for interest under Section 35A on claims for debt or damages. In other words, Section 44, in providing that we're not liable for civil proceedings, acts as a complete defence to civil claims. Now, this particular kind of provision, this particular kind of shield, has been the subject of analysis before in a case under the Mental Health Act called Ex Parte Waldron, which I could ask your lordships just to turn up. It's at tab 18 of the authorities bundle. And I just briefly explain what the case was about. The applicant is a judicial review application, and the applicant had been compulsorily admitted to hospital under Section 3 of the Mental Health Act 1983, and he was seeking to challenge that decision by judicial review of the decision of the doctors. And the doctors relied, you'll see this marked on page 5.9 of the bundle, the doctors in their defence relied on Section 139 of the Act, which you can see between letter C and D, perhaps just read it to yourself. It is in similar terms to the provision that we are concerned with. And in particular says at Section 139.2 that no civil proceedings shall be brought against any person in any court in respect of any such act without the leave of the High Court. And also Section 1 that no person shall be liable on any ground to any civil or criminal proceedings to which he would have been liable apart from this section. So you've got those two provisions which we say are similar to Section 44.
And only the first one is similar, isn't it?
Yes, sorry, I should have referred to the first one or the second one. First one is much closer. So on the application for judicial review, the respondents argued that effectively prevented that claim being brought. And in that respect, Lord Justice Glidewell, in the authorities bundle, page 547, addressed the question of the extent of the protection against civil proceedings given by the Section 139, and in particular, what kind of proceedings were prevented. And he so sorry, I've got a wrong reference. So page 547, letter underneath letter C, he referred to a previous Privy Council case. And then he says at the end of that paragraph, I accept the submission that the words of Section 139 are not wide or clear enough to oust the jurisdiction of the High Court to grant certiorari. I therefore conclude that the words of Section 139 of the Act do protect a potential defendant against whom neither bad faith nor negligence is alleged, against the bringing of civil proceedings in which there is a claim against him personally for damages. But Section 139 does not prevent the High Court from hearing an application for judicial review or of a declaration to the effect that the respondent has exceeded the powers given him by the statute. And so by analogy, we would say...
That, do you not want Lord Justice Ackner at page 540 of the bundle?
Yes, Mr Brooke relies on the word liable to, not liable in. He submits that the natural and ordinary meaning of the word liable to any proceedings is subject to the possibility of any proceedings. Well, I think there's some force in this point. I accept Mr Lawes' submission that if liable in had been used when the proceedings as such have been properly constituted, whereas the purpose clearly of the section taken as a whole is to bar proceedings in limine, which is achieved by Section 1 and doubly sure in subsection 2. But goes on to say that it leaves open the possibility of granting a remedy of certiorari because civil proceedings are apt to cover civil suits involving claims in private law proceedings. So we say that under Section 44, applying this approach, a claim for damages and a claim for debt, and therefore a claim for interest for non-payment of the debt, or interest for breach of contract, for damages breach of contract, simply cannot be brought because they would be civil proceedings within the meaning of Section 44. And we just to anticipate a possible objection to that, one might say, well, if Celestial can't bring a claim for debt or damages, how would they obtain payment in the face of an incorrect but reasonably held belief about the effect of the sanction? And the answer to that, I suggest, is the one that Justice Glidewell indicated in Ex parte Waldron, is that they can always come to court and ask for a declaration, as what Justice Glidewell suggested. So they can get a declaration about what the position under Regulation 28 is, and once that declaration has been made, then obviously thereafter, we could not continue to hold a reasonable belief about Regulation 28 once the court has declared what the true position is. But what they cannot do under Section 44 is at the same time make a claim against us requiring us to pay debt, damages or interest, because that's a civil proceeding of the kind that Section 44 bars.
And you say Section 4, and because it's liable to, then you're not liable to, you're not liable to the proceedings full stop, including anything which can only be granted in the proceedings.
So it is, if Section 44 applies, it is a complete defence to all claims, all private civil law claims against them. And the correct approach is for a party who wishes to have the legal issue determined not to bring a claim of damages in breach of Section 44, but instead to seek a declaratory relief.
Right, I see that it's 1 o'clock. What I think this case is listed for 1.5 days. How are you doing?
I need to make a short point on this on costs.
Yes.
And then I just need to deal with, fairly briefly, with the Rally Brothers point. Then Ms. Barnes will deal with US sanctions.
Right. Between you, what time do you expect to conclude?
So I think I will be about another half an hour wrapping up that, and Ms. Barnes thinks about 40 minutes.
Right. Okay. 2 o'clock.